All rise. The Kosovo Specialist Chambers is now in session. Be seated, please.
Madam Court Officer, please call the case.
Good afternoon, Your Honor. This is file KCBC 2023-12, the Specialist Prosecutor versus Hashim Thaçi, Bashkim Smakai, Isni Kilai, Fadil Fazliu, and Hayreddin Kuchi.
May we have the appearances from the parties, starting with the prosecution, please.
Good afternoon, Your Honor. Josh Hafetz on behalf of the Specialist Prosecutor's Office, and I'm joined by my colleagues here today, Earl Sullivan, Brent Hicks, Lena Peterson, and Ella Paulsenbarg.
Defense, Ms. Menegon.
Good afternoon, Your Honor. Today I am with Leah Alix Cornelissen, Lirim Gresevsi, and Pravera Axiai for the defense of Mr. Thaçi. Thank you.
Thank you. Mr. Rees, joining us on Zoom.
I am, and I'm assisted also on Zoom by co-counsel Mr. Hugh Bowden and team member Muharrem Halalai.
Mr. Holmes.
Yes, good afternoon, Your Honour. I'm appearing via video link with Omar Solomon, also on the screen, and I believe in the courtroom is Ava Kalb and Alex Baer.
Mr. Young.
Yes, good afternoon, Your Honour. I appear remotely for Mr. Fazia. I'm assisted by Ms. Bachiri and Mr. Musher, who I think are also remotely connected. Thank you.
And Mr. Admiral.
All by myself. Good afternoon.
And I see that Mr. Thaçi, Mr. Kilai, and Mr. Fazliu are joining us as well remotely. And Mr. Smakai and Mr. Kuchi are not attending, having waived their right to be present pursuant to Rule 96(2)(c). We're convened today for the Defense Preparation Conference, which is required prior to the opening of the defense case, pursuant to Rule 119(3). This follows the formal closure of the prosecution's case on 13 March 2026, pursuant to filing 792. On the same day, I issued a scheduling order, filing 790, setting 27 March 2026 as the deadline for the defense to file its witness and exhibit lists, but with the possibility of supplementing those filings by 1 April 2026, that is today, upon a showing of good cause. I also set the period of 7 through 24 April 2026 for the hearing of defense witnesses, which was subsequently extended by email to 28 April 2026. I note that the Smakai, Fazliu, and Kuchi defense teams have filed notices indicating that they will not be calling any evidence. Can I please confirm with each of you, starting with you, Mr. Holmes, that you will not be filing any request to supplement, or I'm sorry, not Mr. Holmes, it's Mr. Young in the first instance, that you'll not be seeking to supplement those filings today?
Your Honour, thank you. Yes, that's correct.
Thank you. Mr. Rees, will you be supplementing your filing today?
No, we won't. Our position is confirmed.
Mr. Admiral?
We won't.
And Mr. Young, I see at paragraph 2 of your filing that you say you reserve the right to make an address during the opening and closing speeches. I understand you to mean that you wish to make an address during closing submissions. Is that right? You wouldn't be requesting to make an opening address without presenting evidence, would you?
Your Honour, obviously, I'll only make a closing speech where I'm allowed to. if the fact I'm not calling evidence means I can only make one closing speech in closing, that's fine by me. But I can estimate a time of some 45 minutes. Thank you.
Yes, I think the position of the court, not having heard any submissions on this yet, but the position of the court would be that really an opening statement should be reserved for a situation where evidence is being presented and that otherwise arguments should be presented as part of closing submissions. I understand that that would be agreeable to you. Is that correct?
Yeah, yes, of course, of course. In England and Wales, we're used to normally making closing rather than opening speeches in any event. So thank you.
Thank you very much. Mr. Holmes, I note that you have listed 4 witnesses on behalf of Mr. Killai whose evidence is tendered via Rule 153, that is in written form. Can I confirm that you will not be seeking today to add any other witnesses to your list?
Your Honor, you can, yes. That's correct.
Thank you. And Ms. Menegon, you have listed 1 witness on behalf of Mr. Thaçi, DHT 01. May I inquire whether you will be seeking to supplement that witness list by way of a filing today?
Not at this stage, Your Honor. Thank you.
May I ask, Ms. Menegon, what is your current estimate for an opening statement on behalf of Mr. Thaçi?
Your Honor, given the fact that we do not intend to call any live evidence at this stage, we prefer to make oral submission at the stage of the closing statement.
All right, thank you for those indications. I think now I should turn the floor to the prosecution and ask whether they have any observations at this stage on the defense's Rule 119 filings.
Only limited, Your Honor. I think it will depend a bit on what transpires for the rest of today, but we will be responding tomorrow, as indicated, to one of the 153 motions, and we're in discussions with Mr. Killai's defense regarding potential agreed facts related to that, which affect our position on that filing. And Your Honor granted the extension for the second 153, which we will file on time next week. I will just note that 2 of the reports contained in Mr. Thaçi's disclosed exhibits appear on their face to be of expert evidence in character, and there has been no 149 notice, and there is no witness necessarily associated with them in the legal workflow disclosure. And so the question remains, if those are opposed, and if there is no basis for the reports, and I'm not saying there isn't at this moment, but we are reviewing that. If there is no basis to submit them on the paper, there is then the question of whether a witness would be proposed, and we haven't heard anything about that. And it also, if that were an expert, and for expert testimony, there is, of course, the Rule 149 and the conduct of proceedings in this case notice requirement around that, which is longer than the time we're talking about. So other than that, I don't have anything at this time other than what comes up in the proceedings.
Well, just before I turn to Ms. Menegon, in respect of that comment that you just made, when you say that the time period under 149 would be longer, can you just please indicate to me what you mean, longer than what, and what do you understand the applicable time period to be?
Sure, Judge. What I intended to say was that Rule 149 expert notice and the conduct of proceedings, I think in this case, which indicated, I believe, 30 days notice of an expert report. But in any event, we are where we are, and my point is what we don't have right now is clarity on what would happen if this is opposed on the merits via paper submission, which appears to be the mode of submission.
Well, my understanding, and again, this is subject to correction, is that the time period prescribed under 149 is 7 days for the period prior to the witness's appearance to elapse, or 7 days to raise an objection, which is actually less, as I understand it, than the period in the scheduling order before a witness can appear who is listed in respect of the supplemental notification. So that's why I was curious about the potential difference in notice periods.
Your Honor, I don't have it in front of me memorized, but I believe in the conduct of proceeding, it notes, and it may be paragraph 35, that the notice requirement for the disclosure of an expert report, if that's what it is 30 days.
Ms. Benegon, do you have any comment about those materials that are on your exhibit list?
Indeed, Your Honor, at this stage we intend to tender this report through Rule 138, like the SPO did with various reports as part of its SPO case. Indeed, in light of the deadline of 30 days notice that you had previously indicated, this is one of the reasons why we decided not to call these witnesses, because we obtained their report at a late stage, despite our effort to get them a bit earlier. But indeed, if the admission of this report were not accepted, we would likely seek leave eventually to tender their report through Rule 149 by calling them if need be. We have not added them to our witness list at this stage because we do rely on 138. We consider it sufficient and admissible on this basis. But of course, we will file a written submission in this regard. Thank you. And yeah.
But this does have an impact on scheduling. If we are in a position where we are waiting for the bar table motion, first of all, to be submitted and then a decision rendered, and then only then a 149 application brought, that could delay matters considerably, as opposed to, for example, filing a 149 motion and concurrently tendering the materials via a bar table motion. Is that something that would be contemplated? And in addition to that, of course, it wouldn't be unheard of to request a variation of the time periods that have been established in the decision of the conduct of proceedings.
The issue is that in case 6, as a precedent, one of the party had put a witness, an expert witness on its witness list and tried to tender the report in writing, and it was denied, let's say, through Rule 138 because the witness was on the witness list of the party. So we believe that once we put him or her on our list, witness list, you may consider that the report itself is not admissible anymore until Rule 138, which is also why we have decided to go this way.
And
May I add that we had consulted one of the potential witness with regard to her availability, and she had indicated that she would not be available before the week of 8th of May, which is also why we decided to tender the report in writing.
It may be premature at this stage to ask the prosecution this question, but given that you received notice on the 27th of March of a document that we've now heard characterized by the Thaçi defense as a report that they may seek to tender as an expert report, I wonder whether it would be your position or whether you'd be willing to accept the position that the 30 days starts to run from the 27th of March, or not.
I think that would depend a bit, Judge, on when we're talking about the witness would be coming. We need to prepare and analyze for the, the expert to testify. And I will say that the material referenced in one of the reports, the one without getting into the specifics, that relates not to the law and an interpretation of the law, but to the recorded material in this case, overlaps fundamentally with quite a bit of evidence that's just been tendered by the defense and is already, and some of which is already admitted in this case. So there's quite a bit to engage with in that particular report, and so that is my understanding of why the rule is the way it is in the conduct.
And on DHT 01, will the prosecution's position be that the witness should be cross-examined? In other words, that the witness's testimony should be heard in court, or is the position going to be that the witness's testimony is not relevant and should not be heard at all?
Your Honor, I'd like to answer that right now, but quite frankly, we're dealing with a witness who talks about multiple transcripts that have been subject to the verification process and that themselves are subject to another witness's tendered versions of parts of those documents. So that requires quite a bit of analysis before taking a position on whether it is in the first instance, entirely irrelevant and out of line with the proceedings as already ordered by Your Honor in this case, or whether, or possibly in the alternative, if that first grounds were denied, the person must come and be cross-examined.
The reason for the question is that DHT 01 at the moment is actually the only witness who potentially could be heard, who is being tendered, even in theory, as a potential witness to be heard orally in court, assuming that the court were to decide that the witness should indeed be heard orally and should be cross-examined.
Indeed, the witness is available. I will need to confirm exactly the dates of availability, but he's on our list. And so if the Rule 153 motion were denied, we reserve the possibility to tender his evidence under an alternative legal basis.
So my understanding, just to be clear, is that as of now, there is no witness being tendered to be heard by the defense in court, and that the only one potential exception to that at the moment is if there is a denial of the 153 application for DHT 01 and the witness is required to be heard orally in court. Is that correct?
That's a possibility, you know. I note, nevertheless, that the SPO has tendered his various SPO transcript and translation under Rule 138 without calling any transcriber, any translator. So there is also, we submit an alternative legal basis to tender the transcript he created, not his statement, obviously, under Rule 138. So we will also need to consider this possibility. Thank you.
Yes, I wasn't asking that question to discuss the merits, but more just to understand the position in terms of whether any court days should be maintained within the time period that was scheduled for the hearing of defense witnesses. And it sounds as if in order to resolve the 153 issue, it wouldn't be until, certainly not the week of the 7th, but possibly the week thereafter. Can I ask, would the witness be available during that following week?
I will need to check with him, but we would appreciate indeed if you reserve, let's say, some availability for a testimony in light of the observation of the prosecution and of your upcoming ruling. I want to note that we would request in this case, if we decide to tender his evidence through Rule 154, in case you deny our Rule 153 motion, that he would appear by video link, which I hope would make things a bit more simple.
And I would suggest that at the moment, there does seem to be a difficulty if the reports that have been mentioned as potentially being admissible under 138 in the end are not admitted on that basis, and then you seek to have those materials admitted as expert reports. I've heard what you said about the reason for not making that application, that it could potentially prejudice your 138 request. As I sit here, I have a hard time seeing how that would be the case, especially in light of the discussion that we're having now, which is that the purpose is to, as much as possible, expedite the hearing of a witness who you may wish to call.
If Your Honor order us to submit an alternative Rule 159 application, and by confirming that it will not prejudice a Rule 138 motion, we are willing to do so.
Can I ask, first of all, whether the prosecution would be opposed to such an understanding? In other words, that making a 1491 notification immediately would not prejudice their request for admission of the report from the bar table.
Yes, I understand that, Judge.
And you would be willing to accept that it does not, in fact, prejudice a bar table request that might be pending simultaneously?
No, that appears to be the appropriate way to proceed, to give the proper notice and also to allow for the expeditious nature of the proceedings. I don't think it resolves the issue of the time necessary to prepare for the calling of that witness, if in fact that is what happens.
Yes, I agree with you, Mr. Hafetz. We do have the 30 days, and we have a deadline for the end of the hearing defense witnesses that is now less than 30 days from now. So that does pose a problem. But what I would suggest, nonetheless, in light of this discussion, that indeed a 149 application or notification be submitted promptly.
We will do so, Your Honor.
The court is inclined not to sit for the week of the 7th of April in light of these submissions, because it doesn't appear that there is actually a witness to be heard. And perhaps I should, Ms. Minigon, just pin down one point before I move on. If any of the materials that are now being considered as tendered via 153 or 138, if those materials are admitted in writing, do you wish to make an opening statement or not?
If all the material tendered is admitted in writing, we do not wish to make an opening statement.
And if any of those materials have to come in viva voce, would you then wish to, does that change the position or not?
I presume if we decide, if Your Honor and the defense decide to call a live witness in light of your upcoming ruling, then it would make sense for us to make a short opening statement.
I'm going to adjourn briefly to consider what kind of scheduling order I should issue now in light of these submissions. Before I do that, however, I would like to address one other matter, which is the attendance of the accused during the presentation of defense evidence. I note that Mr. Fazliou has made a request in filing 804 of the 23rd of March, 2026, to attend the defense phase of proceedings by video conference pursuant to Rule 68.2. Is the SPO able to indicate its position on this request?
Your Honor, we take no position on this at this time.
All right, this is an oral order on the request. My view is that greater latitude is warranted in respect of the physical attendance of the accused during the defense case, as opposed to the hearing of prosecution evidence. Accordingly, and having considered in particular Mr. Fazliou's submissions, as well as the position just stated by the prosecution, I hereby grant Mr. Fazliou's request, F00804, to attend the defense phase of trial proceedings via video conference pursuant to Rule 68.2. The registry has kindly requested to facilitate Mr. Fazliou's participation accordingly. This ends the oral order. I would add that I would be favorably inclined towards such request from any of the other accused. I will set tomorrow as the deadline for any such requests to be submitted, and this does constitute a variation of the time limits for such requests as set out in the conduct of proceedings decision. We'll now take a very brief adjournment. I anticipate less than 10 minutes. Please do stay where you are in the courtroom, and we will resume very shortly. Thank you.
Your Honour, before Your Honour rises,
Yes, Mr. Rees.
can I apologise for not being present when Your Honour returns to court? Mr. Bowden will be here representing Mr. Smackey's interests, but I need to depart.
Certainly. Thank you for that, Mr. Rees.
Thank you, Your Honour. I appreciate it.
We adjourn briefly. Thank you.
All rise. All rise. Please be seated.
In light of the submissions heard today and the filings received under Rule 119, it's apparent that there are no witnesses to be heard, at least for the week of the 7th of April. The next witness who may need to be heard, for which court days would be set aside, is witness DHT-01. But that does depend on the outcome of the 153 application, which is yet to be fully briefed. So I will ask the parties to remain available for 14 and 15 April for the potential hearing of witness DHT-01. Again, that does depend on the outcome of the litigation concerning the admission of that witness's testimony in writing. So that's the first issue. The parties are instructed to be available on the 14 and 15 of April 2026. The second issue, and this is an order, the Thaçi defense shall file any request pursuant to Rule 149 by tomorrow at 4 p.m. That request shall include an explanation for not having filed this request by today at 4 p.m., which the court considers to have been the applicable deadline, notwithstanding the explanation that's been presented. But that explanation can be explained further in the written filing that will be filed by tomorrow. That completes this oral order. But outside of the context of an order, I will ask the Thaçi defense to please be as specific as possible in the filing as to when the witnesses, if indeed they ultimately are categorized as witnesses, as expert witnesses, when they would be available. And if they're not available, and secondly, if they are to be presented within 30 days, the just cause for curtailing or reducing the time limit set out in the decision on the conduct of proceedings. And in addition to that, if they are to be heard after the 28th of April, the good cause to justify a modification of the existing sitting schedule. Are there any other matters that the parties wish to raise at this point?
Your Honour, may I
Yes, Mr. Holmes.
please? I'm grateful, Your Honour. As Your Honour will have noted, we have filed motions for the admission of 4 character witnesses under Rule 153. In other words, witnesses whose written evidence is to be admitted in lieu of oral evidence. These 4 collectively have impeccable standing in the community. They are apolitical and independent insofar as these proceedings are concerned, and they speak unanimously and unequivocally about Mr. Kilai's integrity. This morning, we were alerted to the possibility of the existence of material which may prompt the SPO to oppose the 153 application in as much as they would require one or more of these witnesses to appear for cross-examination. Having regard to the criterion Rule 153, Your Honour may feel that it's unlikely that these witnesses ought to appear for cross-examination, particularly since these witnesses relate to the character of the accused only and are tendered for that purpose alone. They do not go to the acts and conduct of the accused. But be that as it may, in light of Your Honour's order, and perhaps I ought to have raised this sooner, but in light of Your Honour's order as to the scheduling of live evidence, if there is to be any, it may well be that if Your Honour finds merit in the SPO's objection and refuses to admit one or more of those witnesses as written witnesses only, that we seek to call those witnesses viva voce, in which case, even though those circumstances may well be remote, there is that remote possibility, Your Honour, that we would seek to call live evidence as well. But it's with those caveats.
Yes, and I understand that this application will be fully briefed by the 7th of April, 2026. So therefore, I would suggest that the dates of the 14th and 15th continue to be useful for that purpose as well, provided that that would provide adequate notice to the witnesses, who I assume, Mr. Holmes, would be, if they do testifying by video conference?
Your Honour, I'd have to confirm that, but we'd like to keep open, if we may, the possibility that that happen. But we'd certainly seek to do to tender them in as efficient way as possible. Yes.
Any comment on that from the prosecution?
Just very briefly, Your Honor, we just heard extensive submissions about the merits of the 4 witnesses called. I'm not going to get into that here. I'm not going to debate the merits and the unassailable information they're providing, including one who's labeled as an acquaintance. What I am saying is what I told counsel this morning, which I think he's responding to, which is that in the very brief time we've had to look into the 4 witnesses that were notified on Friday, we have found some information that we need to bring to the court's attention. And what we're seeking to do, and what I continue to seek to do with counsel, and I'm confident we will be able to resolve it, maybe an additional set of agreed facts relating to statements that one or more of these individuals have made publicly that may affect the weight and manner in which their evidence is considered if these statements are accepted. That's all. So, and I take your point, this can be fully briefed on the schedule you have set, and if it turns out in the unlikely event that they need to be called, that can be done in short order.
Right, thank you. And of course, I do encourage the parties to the greatest extent possible, to consult with one another and seek whether indeed seek common ground as to how to proceed on this matter.
Yeah, Your Honour, may I just thank Mr. Hafeez for doing so exactly that this morning? Yes.
Does anyone else have anything to raise at this point? Yes, Mr. Young?
Your Honour, first I'd just like to briefly thank Your Honour for the oral order in relation to remote attendance for Mr. Fazia. That's much appreciated. And also, without referring to the detail of it, can I thank Your Honour for the written decision on the other matter.
Yes, Your Honour, and just I would like to stress for the record, we did comply with your deadline in order to preserve our right, and the fact that we today inform you that we do not require that LSU complete all the verification requested does not mean that we agree with the SPO transcript. We maintain our challenge. Simply, we do not consider that this process is necessary for our defense. Thank you.
Okay, and just to be clear about this, does that apply to each and every one of the transcriptions that is currently still under review and verification by the LSU?
On our side, yes. Nevertheless, as I've indicated, we are interested to know the result of the review process for the Thaçi material, the Thaçi visit.
So it's not actually revoked for that particular set of transcripts, is that right?
Indeed.
But you are seeking to revoke that request for all the other transcripts?
Given that we are not going to tender such items, we leave it to you whether this process is necessary. At this stage, we do not maintain our request.
Well, I think I would have to, because the requests were made jointly, Ms. Ménégon, I would have to consult as well with the other defendants who jointly submitted requests for verification of the same transcripts. May I just suggest that this be a matter that you consult on out of court, and then if a position is taken that any of the ongoing verifications need not be continued, that you then advise either the registry or the chamber through the registry.
This is noted and will be done, Your Honor. Thank you.
Thank you. Are there any other matters that anyone wishes to raise? We stand adjourned until 14 April at 9:30 a.m., subject to further notification from the chamber. Thank you very much.
All rise.